morning. Welcome to the Court of Appeals. The court will consider 4 matters today. In 2 of those, we were of the view that oral argument would assist our consideration of the case. Those are both scheduled on our 9:30 a.m. calendar. The first of those is in re Heater, and the second is in re J.M., and we'll take them in that order. We allow 15 minutes per side for oral argument. Appellant can save some time for rebuttal. It appears that you want to save 3 minutes. We live stream the proceedings, and pursuant to Utah constitutional mandate, we also make a complete verbatim record of the argument. So 2 important things. Number 1, each time you come to the podium, please state your appearance for the record, so if we have occasion to listen to some or all of the argument down the road, we'll know who was saying what when. Secondly, don't stray too far from the microphone. They're pretty good microphones if you're close, but we lose you if you're more than about 18 inches away. So please make a point to stay by the mic. With those preliminaries out of the way, and I would ask everybody in the audience who hasn't had the chance to do so to please be sure and turn your cell phone to silent. It's quite distracting to the attorneys when a cell phone or alarm goes off, so we would appreciate that. And then otherwise, whenever you're ready, we will call the case of Estate of John Clifford Heater.
Judges of the Utah Court of Appeals, may it please the court, I am Brent Ride, counsel for the appellant in this action. As we've made clear in our brief, the Utah Supreme Court has stated that, or has established, a one set of parents rule for purposes of inheritance. This rule promotes the objectives of the probate code, which are to simplify and clarify the law, to discover and make effective the intent of the decedent, and to promote a speedy and efficient system for administering the estate and making distributions. In addition, the one set of parents rule also promotes peace and tranquility. It prevents unnecessarily impugning the integrity of the family. Now, Mr. Carlon does not dispute the rule. He argues that he didn't inherit any money from his legal father, Thomas Carlon. However, the Supreme Court announced a broad general rule that doesn't depend upon the specific facts of each particular case.
Well, you keep saying the Supreme Court announced, and the Supreme Court, all it said was Section 114 establishes, the statute establishes. The Supreme Court wasn't making any sort of broad judicial case law driven pronouncement, was it? It was just interpreting Section 114.
I thought that it was an announcement. If that's too strong of a word, let me say that this, as you just said, Your Honor, the Supreme Court interpreted the statute to say that there is a one set of parents rule. That was the Supreme Court's interpretation of the statute, and I believe that is binding. That interpretation is binding.
And you don't think that was limited to context, the language that they used there? I mean,
No.
Ultimately, we're interpreting 114 here today, too, right?
And that's the very statute that...
Yeah. And at issue in Hannafin was the question of equitable adoption, which isn't the same issue here, right?
That is correct. It's not. But it is the same statute. And we have an interpretation from the Supreme Court in which the Supreme Court says this statute means you can only inherit from one set of parents. And that, as I've just said, is a sound rule. It makes sense.
But isn't that in the context of an actual adoption? The statute deals with a factual situation where there has been an adoption. Heflin was equitable adoption, as Judge Harris mentioned, but doesn't it make sense in the context of where a court or another entity has established a relationship between adoptive child and adoptive parents and disestablished a relationship between natural parents and, or biological parents and a child, that there can't be two sets of parents in the sense of inheritance or succession. Here we don't have an actual adoption. We have a presumptive father, but there's no court or other entity has established a relationship or disestablished a relationship between these two sets of parents.
Well, I think that the statute establishes a relationship, and I agree with Your Honor that no one has disestablished a relationship. But the Paternity Act is very clear. There is a presumption that because John Carlin was born into a marriage, there is a rebuttable presumption that he is the legal son of Thomas Carlin. And the language of our statute says that that presumption, quote, may only be rebutted in accordance with Section 78B 15607. And the word only in the statute has to mean something. I think that ends the inquiry because there was no disestablishment, and so we have a presumptive father in this case. Now, Mr. Carlin relies on provisions in the probate code, but if there's any conflict at all between the Parentage Act and the probate code, I think this case needs to be governed by the Parentage Act, because after all, the question is, who was his father?
Well, isn't the question, is he an heir?
Well, the question is, may he inherit twice? I guess that's the question. I believe we have a pretty clear answer to that in the Halfland case. And I believe that he can inherit from his father. And I believe that his legal father was Thomas Carlin.
Let me come at my concern another way. This very last page of your brief, you cited us to the current version of the Uniform Probate Code, which is, I guess, different than the Utah version of the probate code. And the uniform version of the probate code has actually addressed this issue, right? And you cited that to us on page 15 of your brief, which I thought was interesting. Do you know how long that change has been in existence at the uniform level out there in the states?
I don't know that, Your Honor.
'Cause I guess I would be interested to know how long that's been out there and how long the Utah legislature has had to sort of make this change, and they haven't.
They haven't.
So my concern is, I guess, more precise. In paragraph 22 of Hannafin, the court says, interpreting section 114, the court says, this section operates to prohibit adopted children from taking by intestacy from both their natural parents and their adopted parents. I think that's right. That's what section 114 did. That's very precise language. And over in paragraphs 24 and footnote 9, they use sort of broader language that you're tapping into, where they talk about it prevents a child from inheriting from two sets of parents. That's true in this context. The language that would prevent a child from inheriting from two sets of parents in your context is extant in the Uniform Probate Code out there in the ether that hasn't yet been adopted by our legislature here. And I'm wondering what to make of all that.
Well, I believe that Your Honor is reading the case too narrowly. I mean, it's true that the Supreme Court says you can't inherit from both an adoptive father and from a biological father.
Because those are the words the statute uses.
But why would that principle not apply equally in other contexts?
Well,
particularly
because of the text of the statute using the phrase natural parents, right? If the statute is still going to use the phrase natural parents, then I think we need to discuss how we would go about defining the term natural parents, which is undefined in the probate code.
Well, I believe that the natural parent provision says that a child may establish, the parent and child relationship may be established, and it also talks about the marital status.
Well,
is
do you
not
take
applicable.
issue with Mr. Lieberman's position that the phrase natural parent is a reference to biology?
Well, his own case is the very case that he says is the closest to this one, says that natural means non-adoptive. And the Webster's definition that he cites also says that natural means non-adoptive. I don't think that natural necessarily means biological.
Are you referring to a state of Olenek, which is the case he says is the closest?
Yes.
All right, the quote from that case is, natural parents means biological or blood, as contrasted with adoptive.
As contrasted with adoptive, that's the language that I think is important.
Biological. So there's no dispute here that we have a biological relationship between Mr. Heater, the deceased, and John Carlin, right?
There is no dispute of that.
So if natural parent means biologic, it indicates some sort of biological relationship. We have a conundrum here, it seems.
I believe that what the legislature was trying to deal with was children who are born out of wedlock, and that they have the opportunity to establish a parent-child relationship. In fact, it's unconstitutional for the state to deny an illegitimate child the right of inheritance. But Mr. Carlin was born into a marriage, and that means something. That's a legal status, and he was born into a marriage, and our legislature has very clearly stated that there's a strong presumption of that. Now, Mr. Carlin had every opportunity to rebut that presumption, but he chose not to do so. And there's something a bit troubling with him being supported by Mr. Carlin his entire life. When Mr. Carlin died, John Carlin was entitled to inherit from him. If Thomas Carlyle had died first, then, the son had died first. The father would have been entitled to inherit from him. The law recognized him as the father, and he was in fact legally required to support his son. If he hadn't, there would have been criminal penalties. And not only did the law recognize him as the father, but the family did. I mean, he took his name, he was listed in the obituary as his son, and so he had every legal right that a child has. Now, some years later, he wants to inherit from another man who was more wealthy, but he didn't follow the procedures for rebutting the presumption. And the statute says the only way that you can rebut the presumption is by following Section 607. That has to mean something.
The only way, what language are you using to infer that that's the only way?
It's Section 78B-15-204, subsection 2. A presumption of paternity established under this section may only be rebutted in accordance with Section 78B-15-607. So there is one and only one way for Mr. Carlin to rebut the presumption that his father was Thomas Carlin, and he didn't do what he had to do under Section 607. So I think that ends the inquiry.
Mr. Wright, I have a question for you back on what I thought was the most interesting part of the briefing, the last page of your brief that Judge Harris referred to, because you rather smoothly observe that the amendment that has been suggested by the commissioners for uniform state laws confirms that this was always the intention. And it struck me that we do have some tension in the statutes. The plain language of the probate code, a natural child, I think, is sort of old-time speak for what we might now call, or the natural father is old-time talk for what we would now call biological father or genetic father. And it seems to say, well, without regard to marital status, you can inherit from your biological father. On the other hand, the presumption of paternity, long settled in the law for children born into wedlock, does really cut the other way. I had a hard time, though, taking your interpretation of what the Uniform Law Commissioners have done. It struck me as being almost the opposite. In other words, it has come to light that we've got this problem now, and language that probably is causing inheritance to go the ways that really is not consistent with normal expectation, and thus the change to specifically recognize that the presumption of paternity, this very language that you've italicized, will work. But I have a hard time seeing how we can retroactively apply that to our statute that doesn't include that phraseology. Clearly, if this were the law in Utah, you would have won on summary disposition. We would not be here today arguing about the case. At least that's my opinion, because that seems so crystal clear. But our version of the code does not include that. So our legislature hasn't happened onto this anomalous circumstance, and I, like Judge Harris, don't know how long this has been out there, but long enough for you to have briefed it and found it and so forth. And so I'm perplexed as to how we can take a more recent suggestion for amendment, not acted upon by our legislature, to give you the help that it clearly would. And I apologize for the length of that comment, but I wanted you to be very clear on what my exact problem is with that argument. I think if our legislature had adopted it, we would have the traditional question, okay, is this a change in the law, or is it a mere clarification of what was always the law? But I don't think we get to that interesting question if the legislature has just let the recommendation sit unacted upon. So I'd be interested in your thoughts on that.
No, I agree with that, and it's clear that they did not act, as Your Honor has just said. By the same token, they have let stand the long-standing presumption of paternity. They didn't fix that either. And that's been around for a very long time, and it serves important purposes. And I think that it is the more specific, to the extent that the court feels that there is a conflict, I think that the paternity statute is the more specific statute, and I think it should apply here. The question is,
what about, to the extent there's a conflict, why don't we just apply the probate code? The probate code says for purposes of intestate succession, this is the definition of how you determine who's entitled to it.
It talks about natural parent, and I think that that is still an open question. I think that I think that the point of that was to say that children born outside of wedlock could inherit, regardless of whether the parents were married or not. I think it's a statute that dealt with illegitimate children. And my point is that when you don't have that, it no longer becomes the most pertinent statute. We have a marriage. We have a presumption of paternity. That has to mean something, and I think that that's the more specific statute and the one that should be followed.
Thank you. You were about to sit down when my long question, followed up by Judge Harris's much more succinct question, put you over your time. So we'll give you your full 3 minutes on rebuttal, and we'll hear from the other side.
Thank you.
Thank you. Good morning. Ben Lieberman for John Carlin. May it please the court, counsel. I'd like to begin with something that is unfortunately not in the briefing and not something that was addressed, but is a case from the Utah Supreme Court that has been decided in the interim, and it's the case of Castro versus Lemus. And I believe that that case is dispositive of all of these issues. I don't believe necessarily that for the reasons that the court has articulated, we even need to get to the Castro case, but my feeling on the Castro case is that...
When was Castro decided?
It was decided in December, so about 2 months ago. The briefing in this case closed, I think, in June. We had a long time scheduling this oral argument, but the site on that is 2019 UT 71, and it's the leading case in a series of Paternity Act cases decided in December by the Utah Supreme Court. And again, I don't think this case turns on Castro because I don't think we get there, largely for the reasons that are both articulated in our brief and that the court has discussed with Mr. Ride. But I do think that case is the silver bullet for all of these arguments, because all of the arguments that the appellant is making funnel into the issue of Thomas Carlin is the presumed father. And Thomas Carlin is the presumed father, and under Section 607 of the Parentage Act, you can't challenge it because there's no standing. And Castro rejected that. And what Castro said was that anyone who has standing under Section 602 of the Paternity Act can challenge and rebut the presumption under Section 607. So the fact that there is language in Section 607 that this is how mother or father may or support enforcement agency may challenge these presumptions. The silence as to other parties did not remove their standing.
But even under the even under the statute, the person at issue, the child, in this case, your client, would have had the right to challenge paternity even before Castro, right?
Well, I mean, he did in this case.
What Castro said is this bio dad who's outside the bio dad who impregnates the married woman does have the right to challenge paternity. That's what Castro said. Whereas before, one of our cases, that RW case, said you didn't, right?
Right.
Okay, so, but even before Castro, unless I'm missing this, the people who were statutorily entitled to challenge paternity included the child, right?
Well, they did, but I think the prior case law said that if you're not recognized in Section 607, then you don't have standing to make that challenge. And
Well,
so
your client had standing all along to challenge paternity here, well, ever since 1967 or 1968, right?
well, and he did. The facts of this case are that paternity is challenged under 607 of the Parentage Act. It can be challenged at any time. There's not this
Challenged in this case?
in this case.
Okay, so
and it was rebutted. It was conclusively rebutted with genetic testing, and that's not challenged.
That makes more sense. I thought you were referring to some other challenge,
No.
or that you didn't have the right to make a challenge until Castro, and I was having a hard time with that.
So there is no limitation on when paternity can be challenged. And so again, I don't know that we even get to this issue, but the district court was correct in allowing us to make that challenge. It was a challenge under 607 subsection 3 with genetic testing. We weren't precluded by other portions of the Paternity Act, whether time or other procedural nuances or standing or anything like that. And we did. The presumption was conclusively rebutted, and that factually is not challenged. And so the argument has been made, and really it all funnels back into this argument that, well, the district court should not have allowed you to rebut. The district court goes through the analysis in the order for a page and a half or so on the facts and says there was this presumption and it was rebutted, and here's the facts upon which it's rebutted.
I thought the argument being made is you needed to do that while Mr. Heater was still alive.
And I think that is an argument.
Or while Mr. Carlin was still alive.
And I think that is part of the argument. I think that's wrong. I think it's easy to see under 607 that can be done at any time. That the court, the legislature could have said that a child can only challenge paternity in the lifetime of the father or the presumed father, or left some other measurement by which there would be a limitation on when the child can challenge. But under 607, under 606, it says anytime, and that includes when both of these men are dead, and we're dealing with this in a probate context. It's certainly not limited by that. But each one of the arguments is premised on the fact that we shouldn't have been allowed to rebut the presumption. But we did, and so the dominoes fall with the rebuttal of the presumption. With respect to the one set of parents rule, I think the main point that I want to make, beyond just regurgitating the contents of the brief, is that speculating as far as what could have happened. He could have, Thomas Carlin could have inherited. John could have inherited from Thomas. Ultimately, I see this as an estoppel issue, that if there was an action, and if John took a position that he was the son, you may have an issue, a judicial estoppel issue. We can have the academic conversation about what could have happened if that happened, but it didn't. There's nothing to stop John from taking the position that he is the son of Mr. Heater, that he could inherit from Mr. Heater, even if there is a firm one set of parents rule.
No suggestion in our record that he authored the obituary that referred to him as being the son of his deceased putative father?
Doesn't stop. He's never taken a position successfully before a court. The fact that he may have held himself out, or they may have held each other out, or whatever those facts may be, he didn't know at the time. He certainly wasn't doing it intentionally. There's no evidence in the record that would suggest that he was doing that intentionally. But, when we deal with judicial estoppel in other contexts, we don't rely on evidence that there was talk in the community of something. We rely on evidence that there was a position taken in a judicial proceeding, that person was successful in taking that position in that judicial proceeding, and that person should now be stopped from taking a contrary position.
By the same token, you would think it completely irrelevant that the father from whom he now seeks to inherit had been dead for 8 years before that even came to his attention?
I think that is a fascinating part of this case, but completely irrelevant. There are a lot of things about this case that are fascinating and bizarre, but they're not legally relevant for the purposes of this appeal. This case doesn't turn on any one of these admittedly very interesting facts. Lastly, I want to address this issue of the may be established language of Section 114 of the Probate Code. As we stated in the brief, the permissive language of may, I think, is relatively self-explanatory, but this issue of established is used repeatedly in both the Probate Code and in the Parentage Act, and it's important. The purpose of this language, and it's stated in the case law that we cited from other jurisdictions, that this is supposed to be a way to make it easier for people to establish paternity. It's not supposed to throw everyone in the probate context into all the procedural nuances of the Parentage Act. And so that's why the word established, there could have been a more neutral word that the legislature used, or the drafters of the uniform statute used, such as maybe addressed, maybe proven, maybe, there are lots of other words that could have been used, but the word established is used purposefully, supported by the case law from other jurisdictions, that we are trying to make it easier for people to prove their paternity, not to open up an avenue for people to disprove or throw these cases into the chaos, which is really not intended. The two statutes really have very different intents. Unless the court has any other questions. Oh.
Apparently not.
Thank you.
Mr. Ride, 3 minutes.
Thank you, Your Honor. It's Brent Wright again on behalf of the appellant. I just would like to make 4 points quickly. With respect to whether Section 607 was followed in this case, merely because there was genetic testing, the answer is that it was not. In fact, the statute clearly provides, and let me give you the cite, it's Section 603, says that the following individuals shall be joined, and one of those is the man whose paternity is to be adjudicated. And so our whole point is that it is now too late, that there are deadlines. The law's full of deadlines, and one of them is that if you're going to do this, you need to do this before Mr. Heater dies. Mr. Carlon suspected for a very long time that Mr. Heater was his father. That's well established in the record. His own affidavit says that Mr. Heater drove his mother to the hospital when she was giving birth. He bought her maternity clothes. He paid for daycare. He's known for a very long time, and the statute has a deadline. Number two, this may be established. The word may, Mr. Lieberman suggests, is permissive. It just simply means you're permitted to establish it. If the statute says you may operate a motor vehicle by complying with the Motor Vehicle Act, well, yeah, you have the opportunity to operate a motor vehicle, but if you want to do it, you have to comply, in this case, with Section 607. That's how it's established. The legislature has spoken. Third, I urge the court in deciding this case to keep in mind the legislative intent. We don't have to guess. We know that they want the code to be interpreted in a way that will simplify and clarify the law. I don't think that these kind of late claims about paternity do that in a way that will discover and make effective the intent of the decedent, and that will promote a speedy and efficient system for administering the estate and making distributions. And I don't think that these kinds of late claims accomplish any of those goals. Finally, there's been a suggestion in the briefs that the legislature or that the law honors nature over nurture, and that is actually incorrect. The legislature honors legally established relationships. It means something to be married, and the law recognizes that there was a marriage in this case that had implications. Mr. Carlon was free to disagree. He was free to take action, but he did not do so. Instead, he inherited, or stood in line at least to inherit. He was an heir of Thomas Carlon, and I think that ends the inquiry. I appreciate the court's time, and I see that mine is up.
Well, we appreciate the arguments. It's a interesting legal question indeed against a rather bizarre set of facts, as counsel conceded. We will take the matter under advisement, do our best to come to the correct decision in resolving the matter, and give you a written opinion when we're able to get that accomplished. Thank you again. Take all the time you need to get organized, and when you've cleared the tables, we'll invite counsel in Ray J.M. to come forward and get settled. Take this one. I don't know what's up with it. It may be that if you, one kind you push a button, one kind you loosen this. Does yours loosen? Loosen that just a titch, and then I think you'll be able to pour. Okay. We do have some that are the push button that you were trying to do, but I don't think they're out today. They may be at DI, in fact, at this point. Whenever you're ready.
Thank you, Your Honor. If I could reserve 4 minutes for rebuttal. Thomas Lux for the appellant.
Did we get that in the record? He was some few feet from the microphone? Okay.
Good morning, Your Honors, and may it please the court. We are here today because my client, the mother in this case, did exactly what she was asked to do, yet the juvenile court terminated her parental rights, her fundamental constitutional right to raise her child anyway. In child welfare cases, after adjudication, after the problems that face a family are defined, we come 30 days later for a disposition hearing where we tell the client that if you do this list of things, that the problems will be addressed and they'll be resolved and your child will be returned to you.
Well, but it's not a guarantee.
Well, it's not a guarantee. But if you solve the problems and you do everything that's required in your plan, and we're not ready to restore custody, then one of two problems exist. Either the plan is deficient, in which case we have a reasonable efforts problem, or the fact of the matter is that we don't have full compliance with some part of the plan. As the ML case states, and the central issue of this matter is the concept of current fitness in the context of whether grounds exist to terminate parental rights.
Why is that the central issue? The juvenile court found 4 grounds, right?
Mm-hmm.
And one of those is neglect.
Yes.
And as I read the statute, the neglect is not a present tense inquiry.
Well, it's
Neglect is a has neglected. Isn't that the phrase used by the statute?
that's the phrase used by the statute, but we also have the case law that says we have to be below a minimum threshold of fitness.
For the fitness. So the juvenile court found fitness as well, right?
Well,
So-
the juvenile court found that she had completed all aspects of her family plan.
What were the 4 grounds that the juvenile court found?
I'll have to read through. So she found neglect, she found unfitness or incompetent, and my essential argument on appeal is that was incorrect because she had completed all aspects of her child and family plan.
Right, but my overarching question is, so I get that this whole concept of past versus future conduct is a really interesting and necessary inquiry when it comes to determining whether a parent is unfit or whether a parent has failed to parental adjustment, whatever the phrase is used. I mean, those are sort of present tense inquiries that the court is making at the time of the termination trial, right?
Well, it's at the time of the termination trial.
Right,
Yes.
like I just said. So, but here we have a separate ground, neglect, and
Yes.
that is not, as I understand it, a present tense inquiry. That's a past. That's a look back. Has neglected.
Well,
And
Your
so
Honor,
if we have one ground, don't we just flip all the way over to best interest at that point?
Well-
And then we look at that point as part of the best interest inquiry, we look to see whether it's in the best interest of the child, and at that point we may look at some of these issues you're talking about.
no, Your Honor. And the reason being is that neglect is a ground, but we're looking at the current time of trial. And how I would explain that is, we have almost every parent that comes before the juvenile court has. There are some dependency cases where there are no fault findings, but most parents have a finding of abuse or neglect. I don't think the legislature intended that in all the cases where parents have neglected their child, that all we're looking at is best interest and strictly necessary. The ground inquiry is at the time of trial. And the question would be, is there neglect at the time of trial?
Well, let's take abandonment then, which is a different ground. All right, that one's also, it seems to me, under section 507.1, that one's a look back.
Yeah,
Right.
and if I just,
Has the parent abandoned the child? At that point, we're not looking at whether something's going on now. We're looking for the grounds. We're looking at whether that ground exists.
and just to clarify, Your Honor, that was not a ground
Well,
found,
I
right?
understand,
Okay.
but I'm throwing a hypothetical at you.
So,
in that case, we wouldn't be looking at past versus future conduct, at least not at the ground stage, would we?
you would have to find unfitness based on abandonment, and that's been in my brief, the JP case.
See, this is where I'm having a hard time following you, right? It seems like if we have abandonment, then there's a ground,
Yes.
and we move on to best interest.
Abandonment is a little more finite than neglect. Neglect is kind of an ongoing process throughout the child welfare proceeding, and if reunification is the goal, the plan of the juvenile court is to correct that. If you've abandoned a child at the time of trial and we look back and go, there hasn't been a relationship, then yes, at the time of trial, you would have abandonment. However, in this case, we have a mother who's made all her visits, who is in treatment, who's actively involved in doing parenting classes at treatment, actively involved in getting her child returned to her custody. In the neglect standard, I would just again, Your Honor, reiterate that I find it doubtful that the legislature would simply say, if you've neglected your child, then you already have a ground to terminate permanently at the time of adjudication, when almost all the parents that come before the juvenile court have an abuse or neglect finding. And in support of that, Your Honor, I would point you to the In re JP case in my brief, the 1982 case that said, if you don't find a threshold level of unfitness, that you don't, then to terminate parental rights violates a parent's fundamental constitutional liberty interest. So I would say that in the statute, when we're looking at the grounds, at the time of trial, the question isn't has the parent neglected the child? The question is the parent unfit because she has neglected her child? Is the parent unfit because there's been a failure of parental adjustment? And I want to address failure of parental adjustment because that's the biggest contested ground in the briefing here. And the question is, has mother within a reasonable time corrected the circumstances that led to the children's removal? And Your Honor, we have a mother here who at the 12-month mark, which is the time that, as we heard earlier today, the law is full of deadlines. And the time for reunification in most cases is 12 to 18 months, or at least the legislature allows for that amount of time. I moved to reinstate reunification services for the mother whose services were terminated at the 9-month mark, at the 12-month mark, the year mark, and the juvenile court found that she had done all these things, that she was actively engaged in every aspect of her child and family plan, and she said, and the juvenile court said, I'm going to also find that the mother has done amazingly well on her own, and that the mother doesn't need services anymore because of how well she's doing on her own, and so we'll just set it for a termination trial. At the 15-month mark, if there was still work to be done, that's when we had trial in this matter. At the 15-month mark, which is still before the drop-dead deadline in the statute, the court could have made the finding of substantial compliance by clear and convincing evidence and extended reunification services, worked a transition plan toward getting the child back home, and that goes to the strictly necessary argument of, is there an alternative determination? We only want to terminate when it's the absolute last resort because of the fundamental constitutional liberty interest. And we can rehabilitate this parent's ability to parent if we still think there needs to be in 3 months. We can restore custody at the 18-month mark and continue working with the family in a PSS case as long as necessary. Of course, if there were mishaps during that time, the child could be removed again, and that would be another story. When services are terminated, the court has held the INRI ML case that although it may be a difficult feat to accomplish, a parent may correct circumstances such that the juvenile court cannot find by clear and convincing evidence that grounds exist to terminate parental rights. Given that that's a difficult feat, it's not an impossible feat. We have a parent who has completed every aspect of her plan, and the juvenile court found that she is, and the unrefuted testimony at trial is she's completed everything. The juvenile court found that. I don't think the legislature or the courts intend to say that if services terminate and the goal is changed to an adoption, that the parent should just give up, and that if we have compliance in that interim period with services that they've created on their own, I think it's a misreading of those cases to say the goal's adoption, we're done here. If that's the precedent we want to set, then we may as well terminate at the permanency hearing, but we have a right to a trial after the permanency hearing on the termination to determine if even in that amount of time the parents have accomplished that difficult feat in re-ML. With regard to the failure of parental adjustment, the The question is, did she do it within a reasonable time? The services were terminated at the 9-month mark. At 12 months, she was in substantial compliance. Services should have been reinstated because she corrected that within a reasonable time. We haven't defined what that means, but the legislature gives us deadlines, 12 months and 18 months.
So the juvenile court's finding that mother failed to comply within the first 6 months is error or is
No.
irrelevant, I guess?
No, it's not irrelevant, and you can set a permanency hearing at 6 months. But the question is when we get to termination, do we have a parent that's corrected the circumstances? I agree that if a parent's not doing what they're doing, it was not an error of the juvenile court to set an expedited permanency hearing. The error is by disregarding the current fitness evidence as we get toward the termination trial. And my time's up.
Thank you. As you're taking your seat, before we hear from the other side, about cell phones, I should have mentioned at the outset when I reminded the group to silence their cell phones. I should also have mentioned that photography and filming is not permitted in the courtroom. There is a limited exception for that. An application can be made with the court 48 hours in advance or some such thing, and occasionally we will permit it. But without that order having been entered here, I'd ask you all to refrain from taking pictures, although you're free to have your cell phones with you so long as they're on the silent mode. Whenever you're ready.
Martha Pierce, attorney guardian ad litem. May it please the court. Fitness goes to the child. In law school, we learned about, when we were studying torts, we learned about the eggshell plaintiff and that you take the plaintiff as you find him or her. And that is true in the case of fitness. It's fitness to parent this particular child. And in this case, these girls were small. They were tiny when they were removed. And the Child Welfare Code is developmentally sensitive. That's why we have the firm deadlines. And that's why the reunification period times from the initial removal, because it has to be the point of view of the child. Now, these girls were so little when they were removed and their developmental task at that point was to attach. And during the time they were with foster mother, they attached. And from their point of view, this was their mom, this was their dad, this was their home, their familiar surroundings. And while their relationship with mother may have been something warm and loving, I would refer this court to In Re AFK 2009 Utah App 198. And that was a case this court decided between two sets of prospective adoptive parents, where one set of parents pretty much abandoned the child, but then began visiting again and developed a warm and loving relationship, which is what this court found. But they said that was a secondary relationship. That was more like a babysitting relationship. That wasn't the child's primary relationship. And in this case, so a reasonable time is going to be a very different thing for babies than it is for a child who's 8, 9, 10, 12, because that child knows who may be bonded to their mother or father, and they know who their mother and father is. But it's a very different thing when we're looking at babies, when we're looking at little children. This court, and I want to address the Rule 404 issue. I would suggest that this court cannot reach it because of invited error. That was where the objection was you can't look at the removal of mother's oldest child, the circumstances of the removal. And there were several times on the record where there was waived objections. The first one was when counsel waived objections to the admission of the adjudication order, which included information about why the oldest child was removed. The second one was in his answer to the petition, where he admitted the circumstances for why that child was removed and why the permanency goal was changed. He also waived objections to the drug evaluation and the psychological evaluation. And finally, mother opened the door to that when she said things like, well, nobody ever told me about drug court, nobody ever told me about House of Hope. And she had this whole other case where she was ordered into services, where she was ordered to get a timely assessment, where she did attend drug court and was informed of that, all of that. So I would suggest this court cannot reach the issue because of invited error.
Ms. Pierce, will you address the question I put to Mr. Lux about why we're even talking about fitness in this context, at least in the context of the grounds inquiry, since there seems to be an undisputed ground here that there was neglect?
I would agree with this court, and that the neglect was ongoing, because mother's neglect in getting the assessment and
Well,
going,
but does the neglect even have to be ongoing?
well, that would suggest that neglect cannot be fixed. And that would suggest, and in this case I have to argue, that would suggest neglect cannot be fixed, and that neglect would not merit a reasonable efforts.
Well,
But I agree that the court,
I'm just looking at the statutory language, which is where we have to start and end, kind of.
You
And
do.
it says, the court may terminate if any one of the following is present. B, that the parent has neglected the child.
and I agree with that, and I guess that would have to be reconciled with the doctrine of present fitness. And so that's what I was addressing when I was talking about present fitness, that you have to look at fitness to parent this particular child. But I would agree that that is what the language says. It says has neglected, has abandoned, all of that. It's a retrospective look. And so I'd agree with this court.
And so
that
we have a ground.
you
And
have a
then we
ground.
just move to best interest. And at best interest, we can look at all that stuff.
We can look at all that
We can look at how she's doing. We can look at what's in the best interest of these children.
And I think that addresses the redundancy in Utah law, because Utah law, you have to prove neglect at the adjudication, then you prove it again. But the parental presumption has already been rebutted. So I think this court is correct in its analysis that it says has neglected, and so you can move to best interest on that issue. Let's see. And I think I addressed, but in summary, mother throughout this whole case and throughout her older child's case was ordered into services, and she neglected to get even an assessment. And the only time she did get into House of Hope and stayed there was when it was an alternative to jail time. And I appreciate that she engaged in it, but by that time these little girls, they had moved on. They had new parents. And that's what the Child Welfare Act asks us to respect, is from their point of view, their best interests. So unless there are questions, I would thank this court for its time.
Thank you. We'll hear from the state.
Hey, Police Court, John Peterson on behalf of the state of Utah. I would just start note that I actually agree. I do agree with you, Judge Harris, that I think, it may be in some respects, a difference without a lot of importance, but it is analytically, if neglect has occurred, neglect has occurred, but best interest by nature, especially now in light of this court's opinion in BTB, does include an inquiry whether or not termination is strictly necessary, which would obviously include the question of, well, if mother's gotten her life together and is now a fit parent, that maybe it's no longer strictly necessary. So maybe it's a question of where that inquiry comes in. This court's always noted that the facts that are relevant to the grounds are also oftentimes relevant to best interest, and there's some interplay back and forth. But I think you are correct, logically speaking, that that's the way the steps should go in order. I would start also by noting some disagreements. Counsel suggested that, I think out of the chute, that his client had done everything asked of her, and I would disagree with that. Because what was asked of her was to begin timely working on assessing her problems. And what she did is nothing. What she did is to continue using drugs for approximately from March till November when she was arrested. And the only reason she stopped using drugs was because she was arrested and she was in jail until January of 2019. So, strictly speaking, she didn't even stop using drugs. She was somewhat forced to stop using drugs. And at that point, to her credit, she does appear to have started, at least, making some efforts to improve herself. But that doesn't change the fact that we're dealing with a person who's been using methamphetamine since they were 15 years old, and using an incredibly addictive drug. And while she has made some success, the only reason she stopped was because she's incarcerated and on probation. And she also didn't do what was suggested would be the appropriate thing to do with a person with that substantial history of substance abuse, would be residential treatment. It's just she didn't really want to. it was, you know, it's going to be a big impact on her life, and maybe the course she's taken will work. Maybe she will remain drug-free. But the experts in this suggest that the more likely way to drug-free is not to attend some day treatment, AA meeting kind of thing. It's but to enter a really intensive program and fundamentally deal with like the problems that have plagued you, in this case, substance abuse. And I think the juvenile court is correct in, you know, in expecting, you know, if you had began.
Well, didn't she do that after she got out of jail?
I mean, she did. I mean, she started working in the house, but she would. I mean, she was still doing day treatment, going to meetings, and I mean, there's quite a list that the court entered of exactly what was required and what she didn't do, but it wasn't ever exactly the level of treatment that was recommended for her. I mean, it may be working for her, but I think more importantly too than, I mean, necessarily which level of treatment she was pursuing is really when she was pursuing that treatment. And if she'd begun pursuing the same treatment in March, when the children were removed, then within a year, I mean, they might not even terminate services, maybe not even have gone to termination.
And so the district court found, or the juvenile court found that mother completed residential treatment at the House of Hope in May of 2019. So you're
Okay.
saying that residential treatment is
okay.
different than what she was
No,
asked to do in the beginning?
I sorry, I misspoke.
I thought that
Yeah.
was, I thought that was what
Yeah,
she was
it
asked
was.
to do in the beginning. She just did it late.
She did it late, you are correct, I'm sorry. Yeah, that's right, there were findings up front that she didn't do as expected during the course of the case, but late in the case she did eventually do the residential treatment. But again, I think the court's main point was that would have liked to seen, you know, a longer track record of success. I mean, because I believe the termination trial began in June of 2019, and she was still, she wasn't released from jail until January of.
Well, she was released from jail in January and then completed residential treatment at the
Yeah.
House of Hope on May 22nd, about, 4 weeks before trial.
Correct.
And that's the complaint I think that you guys were lodging and that the juvenile court picked up on, is that she only had a track record of 3 or 4 weeks out in the community. Right?
Exactly.
Am I understanding the timeline correctly?
That is exactly the correct timeline. You know, I think there are cases this court has noted. I cited a couple examples in my brief where there's a difference between you can be in your treatment program and be quite successful, put you out in the community where you have to deal with day-to-day affairs and paying your rent and getting a job, not to mention raising children. And that's
So why didn't the juvenile court, if that was the concern, why didn't the juvenile court give her a few months to see if she could succeed out in the community after completing residential treatment?
I mean, I guess the point is how much is too much, how much is enough. The children have been, you know, in a placement, a stable placement since removal. Those people have been dealing with their, you know, as Mr. Pierce noted, the fragile medical needs of one of the children. And I believe Mr. Luck suggested this kind of wait and see approach. Let's just keep kicking it down the road a little bit. But at some point, I mean, do you know, like, oh, maybe we'll put the kid back with mother. Oh, now she's not doing so well. I mean, it's a judgment call. I believe, you know, and the court spends the time with people, sees the way the case is going, and do you gamble with a child's life, a young child, medically fragile child, children who've been in a stable home, and say, well, we're going to gamble with you, Mom, because you're kind of doing well. I'm not convinced that you're going to make it.
Was there ever any request to continue the termination trial?
I don't believe there was a request to continue termination. There was a request at one point to
Extend service.
end services. But services, I mean, they were never actually reinstituted after they were terminated. She did what she did on her own. I mean, much to her credit, but. And again, I mean, I think that the court reasonably believed that the disruption to the children wasn't mother's belated compliance under, you know, arrest, and at the very last moment didn't warrant kind of rolling the dice with children. I mean, and there is a certain psychological component of that too. It's like, oh, your mother's doing really well, and we're going to, you know, step things up. It looks like you might get to go home. Oh, no, you're not going to get to go home because Mom's using drugs again. And that was the, you know, the reasonable decision that the juvenile court made. And the juvenile court, you know, is in a better position to make those sort of judgment calls because it's seeing the people in front of them and has a sense of what's been going on in the case and where things are most. I mean, no one has a crystal ball. No one knows exactly what's going to happen in the future, so people have to make the best decision they possibly made. And under the facts of this case, I think the juvenile court's decision to ultimately terminate was within its discretion. If there are no further questions, I will submit to the court. Thank you very much.
Thank you. Rebuttal?
Yes, Your Honor. As the
Mr. Lux again, correct?
I apologize. Yes, Your Honor. As the court picked up on, the juvenile court could have given mom another chance, and there were 2 requests to extend reunification services within the period that we normally allow parents to complete reunification services, which goes to the strictly necessary component.
But was that before the services were terminated, or
Well-
was that during the period of where the services were in place?
To answer your question, it was after services were terminated, but to extend reunification, well, let me take that back. At the permanency hearing, I asked to continue services when services were being proposed to be terminated, and then afterwards. There would be no reason to ask for services to continue while services are ongoing.
Right.
But regardless, there was an alternative to terminating parental rights. With regard to the staying out that the juvenile court picked up on, that she hadn't had time out in the community, that was against the clear weight of the testimony, and that wasn't specifically in the findings. The clear weight of the testimony from all of her treatment providers was that they had no concern that she was going to be able to maintain sobriety. Your Honors, we routinely in juvenile court return children to parents who have been in and outside of home placement for longer than 12 or longer than 18 months when mother was found to be in compliance. And had services been ongoing, mother would certainly have a trial home placement with her children by either the 12 months when the court found she was doing extremely well and her current circumstances were looking pretty dang good, or at the 15-month mark when the undisputed testimony indicates that she had completed each and every requirement of her plan. The caseworker on cross-examination, has mother completed every requirement of the plan you set out for her? The answer was yes. With regard to best interest, there was the parenting coordinator at House of Hope testified that she had a bond with children. I want to address her children, and that it would be difficult for the children if her rights were terminated. Your Honor, this is a fundamental constitutional liberty interest, and I agree with Ms. Pierce that fitness has to do with the fitness to parent a child, but our legislature indicates, and the policy of the state and the national government is that it is in the best interest of children to be raised by their natural parents if it is possible. The juvenile court was premature in setting a termination trial instead of reinstating services that would have been able, so to see if mother would have been able to properly care for her children within that time frame.
And by services, you really mean a trial home placement at that point?
At that point, I think we could have had one.
I mean, what other services would she have needed, right? Because at the time the juvenile court said she's doing pretty dang good, at that point in time she was in House of Hope, right?
Yes.
And so I can see why the juvenile court said, look, I'm not going to extend services to somebody who's in residential treatment. You know, she's being taken care of through other means at that time. We'll revisit that
But
later.
if she
That doesn't
doesn't-
strike me as weird.
But-
But at the termination trial, the services you're requesting were exactly what?
But if she didn't need any more services, then isn't she currently fit? And current fitness, it seems to me Ms. Pierce is arguing that current fitness is not a defense. It is a defense. It's a difficult feat to accomplish, but if she's currently fit, she gets her children back. And to answer your questions, the services I would have asked for were help with housing, because at the time she didn't have housing and employment through workforce services and to pay for treatment. And that's all the time I have. Thank you, Your Honor.
Thank you all. We will take the matter under advisement and do our best to have a decision to you quickly in view of the expedition with which we try and take care of our termination cases. With that, we'll be in recess.